Good afternoon, ladies and gentlemen. Welcome to the Small Firms Guide to Contract Documents, a webinar brought to you by AIA Contract Documents. A few PowerPoint slides before we get started. This presentation is protected by U.S. and international copyright laws. Reproduction, distribution, display, and use of the presentation without written permission of the speaker is prohibited. You will be receiving a PDF PowerPoint of the presentation along with the recording from today's webinar probably by tomorrow. So please stay tuned for that. You will have some follow-up materials in the next day or so. This program is registered with AIA for Continuing Education Learning Units. So there will be one learning unit attached to today's presentation. If you entered your AIA member number when you registered for the course, we will report your credit directly to the AIA, and it should appear on your online transcript in the next 2 weeks. Now I'm going to go ahead and turn it over to Mike Koger. Just a quick question, everybody. Can everybody hear me? If a few of you don't mind just entering into the chat, making sure that you can hear. Okay, great. I believe everyone can hear me, so we'll go ahead and get started. Thank you all for that confirmation. Wanted to just make sure. Now I'm going to turn it over to my colleague, Mike Koger, AIA Esquire, Senior Manager with AIA Contract Documents Content. Mike, take it away.
All right, thank you very much, Hasi. Like she mentioned, my name is Mike Koger. I'm the guy on the right-hand side of the screen. And I have been a staff attorney with the AIA for the past 5 or so years. I started my career as an architect. I've worked in both small and large architecture firms before transitioning my career to being an attorney. So talking about small firm issues and architectural issues is something that's near and dear to my heart, and we are going to be taking the next hour or so of your afternoon and walking through some of the resources and documents that we offer at the AIA, and particularly in our Contract Documents Department, that can help you out, we hope, with your practice. Joining me today is Ken Cobley. Ken is the Managing Director of the Contract Documents Department. And Ken, I'll let you kind of talk a little bit about yourself and tell the folks about, about your background.
Thanks, Mike. So I've been with the AIA since 2006. So actually next week will be my 12th year here. I am an attorney by education and training. And before joining the AIA, I was in small to mid-sized firms in the Maryland area, but with cases smattered across the United States as well, practicing mostly construction litigation, and I worked for, I represented owners, contractors, subcontractors, and design professionals for a considerable portion of that time. One of the firms I was with, we were panel counsel to several of the major professional liability insurance carriers. So that is my background, and again, I came to the AIA about 12 years ago and have been working on contract documents since I arrived here. This affords me the opportunity to put many years of construction litigation experience to good use. And so it was a really good fit for me. So that's my background. I'm going to turn it back over to Mike. I think he's going to go through some of the history and a few other segments before coming back to me in the program. So Mike?
Correct. Thanks, Ken. Yeah, I'm going to be talking for the first handful of minutes here about, I want to talk a little bit about the history of our AIA Contract Documents program, and then I'm also going to go through some of the major owner, architect, owner, contractor agreements that we offer, some of those that are particularly focused on, smaller firm practitioners. Ken's then going to talk about our master agreements, some of our other specialty documents that we offer in the for small firms that might be interesting to small firm practitioners, our design build residential document and our sustainability documents as well. So the AIA has been publishing and creating AIA contract documents for 130 years now. Dating all the way back to the 1880s, we first started creating standard form agreements. Over the years, our document offerings have multiplied and have really evolved to reflect all of the nuance and the complexity of current construction and design industry. 100 years ago, you could have looked at our offerings, and it would have fit into a very small folder, just one or two documents, owner-contractor agreement, owner-architect agreement, relatively small in density and page numbers. Today, we offer nearly 200 agreements and forms. Anything from traditional design bid build documents and forms to design build to 2 different types of construction manager documents, digital practice documents, sustainability documents, and all of those documents really reflect just the amount of complexity and diversity in our industry today. One of the interesting things about the history of our program is that over the last 100 and so years of offering standard form contracts, there has been a good amount of case law that has built up from courts around the country. And so why that could be interesting to you, if you have a question about one of our contracts, say the A201 or one of our owner-architect agreements, you can always call us up and we can tell you what we meant when we drafted that agreement. But we don't have jurisdiction in your state. We certainly don't have any ability to resolve disputes. What you really are looking for is a court decision to help you interpret that particular piece of contractual language. And there is very possibly a court decision out there in your jurisdiction that has already decided or interpreted a piece of language that we have in our standard form agreements. So that helps our documents be more predictable. It helps them be more understandable to folks. When we create our documents, we strive to create fair and balanced documents that represent, the industry standard for design professionals and construction professionals. We do not draft contracts to favor architects. Of course, we are the American Institute of Architects, so we want to make sure that we are recognizing the role of architects in our contracts, but we do not shift risk to unfairly balance those documents to favor an architect over an owner or a contractor. And, occasionally we will get questions about why we don't do that, considering that we perhaps should be. Some folks think that we maybe should be doing that. Well, and the reason is that the Contract Documents Department is not the advocacy branch of the AIA. We want to make sure that we're drafting contracts that are used by the entire industry, and if we were to draft them to be in some way swayed to favor architects, owners and contractors simply would reject them. And one of the reasons that you will see AIA contracts quite often in your practice is because owners and contractors, and as well as architects, find them to be, in large part, fair and balanced and agreeable contracts that they may, of course, edit. When we go about drafting our documents, it usually takes us about 1 or 2 years to develop a document. It is a very slow and deliberate process where we are trying to get feedback from all segments of the construction design industry. When we draft our documents, we're not trying to revolutionize the industry. We are really trying to we want to future-proof our documents to some degree, but we want to make sure that they are really just meeting what the industry is doing right now and responding to the current status of the industry. So Ken and I are both staff attorneys, and we work full-time with the AIA at the AIA headquarters here in Washington, D.C., but we are supported in large part by a volunteer group of AIA architects, anywhere from 30 to 35 AIA Documents Committee members that are scattered all across the United States. And these Documents Committee members, they're all licensed architects, and they are all AIA members, but they work in a varying degree of practices. Some of them work for owners, some of them work for construction managers, some of them work for contractors, and of course some of them work for traditional architecture firms. But they really give us that current, on the ground, up-to-date information about the industry that guides everything that we do in drafting AIA contract documents. So over the over the years, we have noticed some trends in our documents program, and if you've followed us, if you've used our documents, you'll probably notice them and have recognized them as well. For example, today we have more delivery models to choose from than ever before. We offer a number of IPD documents, as well as many of the ones I've already mentioned: construction management, design build, and so forth. We also incorporate all kinds of new stuff into our documents, such as digital practice, BIM, sustainability. All of these things are relatively new, at least from a historical perspective from our program, and they're also things that are evolving every day. I have been out of the business of actually practicing architecture for 12 years, and I can tell you that I would be fairly lost doing drafting work in an architectural office, because the state of BIM and just the practice of architecture has changed that much. And so we have been updating our documents over time to reflect that and those realities as well. So given that we offer so many different types of documents, one of the most common questions that we get is, how do I pick? There's 200 documents, and we have so many people that are asking us questions of, how do I whittle it down to one particular document? The first thing you need to understand is how our document families are organized. And this is the slide that you'll see on the screen here is very helpful to understanding how our documents are organized. We organize documents by families, and a family is really a grouping of documents, usually by project delivery model. You'll see here on the left side, conventional design bid build, design build, CM as advisor, and so on. The golden rule in selecting documents is to stay within your family. If you have picked an owner-architect agreement from a design bid build traditional family, the last thing you want to do is be picking your owner, construction manager agreement for the constructor part, right? Because it's going to be very difficult for anyone, particularly even a court, to make sense of how those documents work together. So stay within your families when you're selecting documents. Another key thing to understanding how our documents are organized is the letter designation at the very beginning of our document titles. An A document is an owner-contractor agreement. A B document is an owner-architect. A C document is an other agreement, but it tends to be our consultant agreements. And a good majority or a good portion of our documents are in the G series, which are our forms, and that's things like our change order forms, our certificate of substantial completion, payment applications. That's where you're going to find those all with a G designation. So now kind of turning to the question of what is a contract and why do small firms need contracts. This seems, to some of you this may seem like an obvious question, but we do get folks all the time that ask us, things like, can a handshake work, and do I really need to have a contract on a small project? So I'll start with just a base and the most common definition of a contract. It is a promise or a set of promises, the breach of which the law gives a remedy, or the performance of which the law in some way recognizes as a duty. So that's, restatement of contracts, pretty much contracts 101 language right there. So let's break that down a little bit. A set of promises in the owner-architect, agreement. An architect is promising to perform architectural services in exchange for the owner's promise to pay a fee. And of course, in a construction contract, you're talking about the construction services in exchange for a fee. When you're reading about contracts, or if you listen to podcasts about basic contractual principles, you'll hear this often called this idea of a set of promises, like a bargain for exchange or consideration, and it is a critical component of having a contract that the law will enforce. If you don't have a set of promises, or if you have one party promising something and another party is not, you might have something, but you don't have a contract. And the second big piece is that idea of the law gives a remedy, that the government will enforce it. Of course, if someone breaches a contract, you can go to court, or you can go to an arbitration panel, and the courts will recognize the arbitration panel's decision. So here are some of the key features of a contract that you need to make sure that you have in there. Things like basis of the architect's design, scope, compensation, ownership of the architect's drawings and specifications. You need to handle that in some way in your contracts. Termination, disputes, those kinds of things. I will go through some of the common bad ideas that I have heard over time from contractors and architects. One, I've often heard particularly smaller scale contractors say, I don't really need contracts because I just get by on my reputation, and if something goes wrong, I'll fix it, and I have a relationship with folks like that. And if you go your entire career and you never have a dispute on a project, well, you got lucky, but that doesn't necessarily mean that you've adequately managed risk in some way. You just got lucky. So you do need contracts for the projects that do go awry. Handshake agreements, it is entirely possible to have an oral agreement and have that even be enforceable. And a lot of folks think that is how they want to do business. But handshake agreement is really worth, as they say, the paper it's written on. When it comes time for a dispute, folks often get a little bit of amnesia as to what they agreed upon. So it's very helpful to have things written down and committed to some kind of agreed upon document. Another thing that is common, particularly with small architectural firms that I've talked to, is they want to do things via a letter agreement. And that is something that the AIA as a contract documents program does not recommend. And the reason is that letter agreements are typically missing, from what we've seen, they're typically missing some of the key components. They might have compensation, they might have a schedule of services or a description of the services the architect is going to perform, but there's nothing in there about, who owns the architect's drawings and specs. And there's nothing in there about what happens when a dispute arises and how's that going to get resolved. So those are three common bad ideas that we hear, and reasons to really start looking towards formalized agreements of some sort. I'm next going to go over a pretty high-level review of some of our more common agreements that we have in our conventional design bid build family of documents. We call this the A201 family of documents. I'm sure everyone on the call listening knows what a design bid build project is, but if you don't, owner retains architect. Architect does the design with their consultants, mechanical engineer, whoever else they need, and then the architect bids out the project or assists the owner in bidding out or negotiating a contract with a contractor who then performs construction. And the next slide is probably one of the most helpful slides that we have. It's a relationship diagram of all of our, well, not all, but many of our most important design bid build contracts. And you can see that relationship diagrammed out here on the screen between owner and architect. You have one of a number of different agreements, anything but the B100 series documents, and I will go over the differences between those B100 series documents soon. Architect and consultant have an agreement. The C401 owner-contractor, we have a lot of different options for owner-contractor agreements, all A100 series designations, and then contractor-subcontractor agreements, A401. The key thing to point out here is that the architect and contractor do not have a contract together in a traditional design bid build scenario. They owe the owner obligations to work with each other, either through the A201 general conditions, or if you're using one of our abbreviated documents, they have, like the A104 and A105, B104, B105, they have the general conditions obligations already subsumed into them. So I'll talk next about our core owner-architect and owner-contractor agreements. Starting at the bottom of the slide here, our core owner-architect agreement is B101. It's our flagship owner-architect agreement. It's the document that we spend the most time editing, to be frank about it, and the most time doing legal research on and those kinds of things. From an owner-contractor perspective, we have 3 different A100 series options you can choose from that will work with the A201 general conditions. A101, 102, and 103. The difference between those is how the contractor is going to get paid. The contractor is going to get paid stipulated sum basis. A101 is your document, cost of the work, A102, and cost of the work without a GMP is A103. So I imagine that many of the folks who are listening on the phone right now are architects working in small firms, and you are wondering which of our owner-architect agreements to use. You've probably used some of our abbreviated and short-form agreements, but I want to show this slide just first of all to show you that we offer a number of different owner-architect agreements, and they really all are variants of the B101. The B101 is our baseline gold standard owner-architect agreement. It's the one that has 100 or so years worth of experience built into it. And you know, if AIA contract documents were a DJ at a wedding and we were not taking requests, this is the song that we would play over and over again, B101. But through the years, we have taken requests, and folks have asked us to develop shorter form agreements for instances where you have an unsophisticated owner and it would be intimidating to put a 23-page document in front of them. And our B101 is a 23-page document. So we have developed B104 and B105, which are abbreviated and short form respectively. B104 is 14 pages. B105 is 3 pages. Now, keep in mind that when you go from a 23-page document to a 3-page document, going from B101 to B105, you are just necessarily missing, you are going to be redacting some of the things that we have thought were important enough to put into our B101, and they're going to be taken out of the B105. So just recognize that when you use a B105, it's a good document and it can work well for your project, but it's not going to have all of the protections and all of the language that we have in B101. We also offer documents for pro bono services, for other kinds of specialty owner-architect agreements, federally funded or federally insured projects, multifamily residential. My advice to most folks is, start with B101 as your standard, and then if there's a good reason to move off of it, you got a client that might be scared off from a large document, then start to think about that B105 or some other variant. This is my last talking point before I transition over and let Ken start to talk about some other documents. One of the more common questions that we get is how do you pick amongst B101, B104, and 105? And I'm going to give you an example because it is very difficult for me to just say, well, one document has X, Y, and Z, and the other has a whole different, or more redacted versions of the same language. We get about once a week, we get a call into our documents information call center, which is something you can, a number that you can call up to get answers to questions that you have about our contracts. And about once a week, we get a call somewhere along the lines of, Hey, I've got a project where, we were doing some excavating in the back of this house for an addition, and we came across something that was buried. It's a utility line. It's something we didn't know about. Utility line, water main, human remains. You would be surprised how common that is. Or some kind of relic or something that looks like it's very old and might need to be taken care of. My response is always, well, which of our owner-architect or owner-contractor agreements did you use? If the answer is B105 or A105, well, there's not a whole lot in those documents to tell you what to do in a unforeseen site conditions scenario. But the B101 has a very thorough, thought-out process for what to do if there's human remains or if there is that, unforeseen condition. So just be aware that that's the kind of dynamic you are working with when you're picking between these documents, and certainly read them all very closely and compare and contrast them before you select on one. So with that, I'm going to turn it over to Ken, who's going to talk about master agreements.
Thanks, Mike. So when Mike was talking earlier about how we develop documents and what we do, he talked about the committee. He told you that we have a fairly detailed drafting process. And part of that process involves reaching out to various entities, segments of the industry, and getting their feedback on what types of documents might serve special needs that they might have. And so 4 or 5 years ago, we had the opportunity to meet with some folks from what was then the Small Firm Roundtable. I think now it's the Small Firm Exchange. They were here for Grassroots, and we went and we met with them to hear some of their concerns and to hear what they might have an interest in. And one of the pieces of feedback we got was that they often found themselves in a situation where they had a really good relationship with an owner, and they wanted the ability to have sort of a continuing contractual relationship with that owner, so that the owner and they both knew what the standard terms would be if they were going to do work, provide services, so that they only had to fill in the blanks for the particular engagement. What's my scope going to be? What exactly am I going to do? And how much am I going to get paid? What are my time constraints? What's particular to this project? But they didn't want to have to each time present and or negotiate the core terms. And we had heard some feedback from others in the industry that this might also be a helpful scenario. And so we set about to create a group of documents that we call the master agreements with work orders or service orders. So in 2014, we published 3 groupings, if you will. We prepared and published a master agreement between an owner and a contractor, and a work order that would go along with that. We prepared a master agreement between an owner and architect, and service order that would go along with that. And we prepared a master agreement between an architect and consultant, and the service order to go along with that. And I'm going to explain a little bit more about this master agreement and work order or service order concept, but you may notice that that's 3 out of 4. So in 2018, in the run-up to this year, so coming out of 2017, we did 2 things. We updated all of the 2014 documents to the extent necessary to incorporate 2017 concepts. So I should start by telling you that each of the documents is based on these more traditional flagship design bid build agreements. So B101, A107, actually now A104, because you can create any one of the 3 payment options, and of course the C401. So in 2018, we updated them all so that they would more closely mirror the 2017 documents with respect to the standard provisions, and we created the missing set, the A421 and 422, which is a master agreement and work orders for use between a contractor and a subcontractor. So how does this all work? Well, as I suggested earlier, the master agreement establishes common terms and conditions that are going to be applicable to all the work or all the services provided pursuant to the master agreement. It's going to have terms in there that cover things like dispute resolution. So if we get into a dispute under one of these work orders or whatever, how's that going to be decided? What are the grounds for termination of this arrangement or of a particular work order or service order? Who has what rights under the instruments of service that might be prepared for a particular project, for a particular work order, and a whole lot more of the basic sort of standard boilerplate core concepts that you know are just going to carry over from project to project. Now, I've been talking about multiple projects. You could imagine this master agreement and work order or task order scenario working in a couple ways. It might be that you have an owner, or you might be the architect, and you might want to engage a consultant for several different projects. You might have a structural engineer that you just love working with. This firm gets it. They price it right. You never have a problem chasing design stuff. They're proactive, and you really, really like them. And so on the vast majority of the projects that you're going to be involved in, you might want to use them. Or there may be an owner that really likes your design work, and it may be a public owner, and that public owner may have the ability to engage you as a small practitioner to do jobs in their portfolio as long as they're under a certain amount, and it doesn't have to be competitively procured or go through a more formal procurement process. Or you may have a private owner that's not subject to procurement laws that can do this for at least a range of projects. You enter into the master agreement, and now you know you can go forward. And with the update, these master agreements are self-renewing, so they're going to stay in effect unless and until somebody decides that they want to declare them null and void. But what doesn't the master agreement cover? It doesn't establish the scope of work or services or compensation. And what I started to go into before is you can use a master agreement for a range of projects, or you might be in a situation where there's a huge project and you can enter into the master agreement if somebody is going to dole out portions of the work, either to consultants or subcontractors, or an owner is going to give pieces of the design. If there's multiple buildings in a single project, you can use it that way. So the goal here is to establish working criteria that get used over and over again with discrete scopes of work as defined in the work order or service order. So the service order is an integral part, or the work order is an integral part of this process. You don't actually have an agreement until you have both, because integral to the creation of a contract would be the definition of the scope you're going to perform and how much you're going to be paid. Remember, Mike talked about those as critical elements of a contract. Well, without the service order, work order, you've got all these business terms, but they don't apply to anything because you haven't defined the scope of work or services to be provided, the promise by the contractor or the architect, and you don't know how much you're going to get paid for the promise, among other things, by the owner. It's also important to understand that if you execute one of these master agreements, there's no obligation on the part of either party to A, issue any work or service orders pursuant to it, or the other party to accept a particular job. You might enter into the master agreement with an owner as an architect, and they may ask you to do 5 or 6 projects, and you go along and do it. Then there's a 7th project that you just don't feel comfortable about, or you don't feel that the firm has the bandwidth at that time. You're not under an obligation to accept that commission. You can say, you know, no, I don't want to do that. And that doesn't necessarily void the master agreement either, but you're under no obligation. Similarly, a well-intended owner could execute the master agreement, and then for whatever reason, the economy or finances being what they are, they're not under an obligation to issue any service orders or work orders under it either. But it's a good way to have the framework in place so that if work does come along, you're 3/4 of the way there, and you can focus on just refining that scope, making sure you know what services you're gonna provide, and what particular elements the owner is going to provide, including how much they're going to pay and how they're going to pay. So that was one concept that we got out of our discussions with folks. Another concept that we heard about that we got some feedback on that people said they'd be interested in is residential design build. And we know that some of you out there actually do this. We know that you will take an engagement where you will do design for custom residential work, and you will also be the contractor. We understand that, we know it, so we tried to develop a contract that would assist you in that endeavor and cover the key components that we thought needed to be done. So that document is the A145 2015, and as the name suggests, it's for owner design build agreement for a 1 or 2 family residential project. So what's so special about this? Well, it was specifically developed for residential design build. So it's not as large and complex as our commercial design build agreements are. Nonetheless, it's got a fair amount of meat. You can see it's got 15 pages, and it focuses on the key attributes that one would expect if one was going to engage with an owner, particularly perhaps not a sophisticated owner, in terms of the development of the owner's criteria, and ultimately documenting and getting through to the building and construction side of it. So you've got the 15-page short form owner design builder agreement, and then to memorialize what happens once the preliminary design is done and the owner wants to move forward to construction, you have a design build amendment that's going to cover how much construction costs are going to be and a few of the other elements. How does this all work? Well, at the beginning, the document prompts the architect and the owner to sit down and provide some detailed initial information. That's going to form the basis for the architects / design builders preliminary design, right? That's what the owner is going to want as part of its requirements. The owner's criteria is based on the initial information that is provided, and that's the stuff that's going to be critical. It's got to be in there. The owner's criteria is memorialized and it's approved before the design phase begins. The preliminary design should reflect all the owner's criteria. But then the design builder has some free range to figure out how exactly to get all of those criteria into the design and construction of this residence. And then, as I said, once you get through the preliminary design and the owner approves it, you get a design build amendment, and that sets the contract sum, schedule, and a few other terms that are going to be key to the construction phase, the construction of this residential building that is reflected in the via the preliminary design. One of the things that this document prompts everybody to consider is, because this is residential construction, because many jurisdictions really key in on consumer rights and so on and so forth, we really prompt you to make sure that you cover any specific jurisdictional requirements that might pertain specifically to residential construction projects as part of the initial information and material. So those are two sort of specialty documents that we worked out based on input from folks in the small firm roundtable, small firm exchange, and that we hope sort of meet some special needs that small firms might have and sole practitioners might have as they try to manage their work. So I'm going to turn it over to Mike now, who's going to talk to you about the B102 and some of its associated scopes.
Yep, thanks, Ken. So I've already, of course, talked about a number of our B100 series documents in the first half of this presentation, but I'm going to spend, I think B102 deserves its own special attention because it is a unique owner-architect agreement that we offer that I think can be very useful to folks if only they knew it existed and they knew how to use it. The official title for this document is Standard Form of Owner-Architect Agreement with no predefined scope of services. And that phrase can be a little bit off-putting or at least a little bit confusing. What does no predefined scope of services mean? Well, all of our other B100 series documents presume some form of traditional architectural services. Those 5 phases of design we learned in first year of architecture school, schematic design, DDs, CDs, and construction administration. The C1 or the B102 does not presume any of those traditional design phase services because the reality is that architects can do more than just basic architectural design. Quite often you are going to be brought onto a project to do things like site evaluation or historic preservation or zoning analysis or code analysis or something like that. Some other kind of, it's a design service that you know how to do, but it's just not your traditional 5 phases of design. The B102 allows you to do those other, tangential kind of design services without having the 5 phases, the traditional 5 phases presumed into your agreement. What you're going to need is the B102 plus a scope of services document. I'll get into how that works and what I mean by that here in just a moment. But first I want to show you what the B102 does have rather than what it doesn't have. It has your basic business terms. It's got things like, what to do, your claims and disputes language. It's got compensation language, copyrights and license kind of language. What it doesn't have, of course, is that actual scope of services. That is something that you're going to either need to draft on your own, or you can take something that we've already created and add it to the B102. We have already pre-drafted a number of architects' scopes. For example, programming, site evaluation, like I already mentioned, historic preservation, facility support, FF&E design. You can see the list on the right. I won't read the whole thing out loud. But there's a number of them that you can already find, and we're probably going to be creating more in the next 10 years or so. So just kind of keep checking back to see if we've already created a scope before you go creating one yourself. But key component here is you have to have the B102 plus a scope, whether it's your own exhibit or it's one of our B200 series. The two of those together create a contract. B102 by itself does not create a contract. You don't have a scope of services in there, so don't just sign that by itself. Make sure you've got a scope attached to it. And I am going to pass the microphone back to Ken. He's going to talk about sustainability.
Great, thanks, Mike. So the AIA tried to took a leadership position when it came to the development of contract documents that would address sustainable design and construction elements on a project. In 2000, and so those of you that may remember back to the 2007 documents, you may remember that we had some very, very, very basic language in there. And that was because sustainable design and construction was a concept that was just starting to get traction in the run-up to 2007. And so the Documents Committee was really torn. There were some people that really wanted to get out ahead of this and thought that this was going to be a wave of the future. Others said, you know, we're not so sure. There's some complexities associated with this. We don't know how it's going to play out. It could be too costly for owners to continue with. And so the AIA Contract Documents Committee took a sort of a middle-of-the-line approach. They added some language because the board had issued a policy statement on sustainable design. But we didn't want to go too far because the Documents Committee didn't know exactly where this was going to head. Well, it wasn't too much after 2007 that we saw that sustainable design and construction in some format was going to be here to stay. We knew that LEED was gaining traction. We knew that California and a couple other jurisdictions were going to go out and really push for, you know, Cal Green and some other stuff. And so what we decided to do was say, okay, well, we'll take a next step. We will develop a guide that incorporates a lot of the elements that we're seeing in sustainable design and construction. We're going to create a guide, and what we're going to do is we're going to instruct people in this guide how to take our basic documents, the B101, the A101, the A201, and modify it so that we could develop a process for infusing sustainable design and construction elements into the standard delivery model, design, bid, build. And so that's what we did. We created a very lengthy guide that talked about all of the issues associated with sustainable design and laid out a process that included, you know, the sustainable objectives, sustainable measures, and so on and so forth. And we talked about how all that could be incorporated in all these documents. And our guide was really well received. People liked the concepts. They liked the process. They thought it was thorough. We had covered the waterfront on it. What they didn't like was the notion that they had to go into our documents and cut and paste the model language from the guide into the documents. And they said, why can't you just do that? What's wrong with you people? Why can't you just put that language in the documents so we can get them with everything in it? And so the step after the guide was to create sustainable projects documents. And so that's what we did for all of the core documents in our design bid build family, the A201 family obviously, as well as our construction management documents, both the CM as constructor or CM at risk and CM as advisor. And so up we roll on to 2014 when we're getting ready to do design build, and we're watching this library of documents burgeon, right? Because for each one of our core documents, we've got vanilla and green. And the Documents Committee said, you know, I'm not so sure this is the most efficient way to do this. Perhaps we should try creating an amendment or an addendum that could fit in all of the documents in a single family and cover the waterfront of everybody's obligations. And so in 2014 with Design Build, we created a Sustainable Projects exhibit, largely built off the concepts from the guide, from the pre-existing documents, tweaked for that delivery model. And then we did the same thing in 2017. So for the 2017 version of our design bid build documents, for the 2019 version of what will come out for CM, you won't have a vanilla and green version. You're going to have one version and an exhibit that will attach to all of the documents being utilized in a delivery model. All right, so that's where we are. Now let's talk a little bit about the process. Each of these documents is going to prompt the architect or the design builder to have a discussion with the owner about the owner's sustainable objective. What is it that the owner wants out of this project? Do they want some sort of official certification from Green Gloves or Energy Star or LEED, or do they just want to incorporate some really good sustainable measures, sustainable elements, green roof, some healthy objectives, some fuel or energy efficiency elements into this project without necessarily getting into a certification? The discussion is, what's the objective? Once the objective is known, then it becomes part of the deliverables for the architect and or the design builder to establish what the measures are to get there. Now, specifically, what are we going to have to do? If it's a LEED certification, how are we going to get the points? If it's energy conservation, what kind of modeling do we have to do? What's the burden that's going to be placed on each of us to get there? And once the measures are identified, then you develop a sustainability plan. The plan designates people who are responsible for achieving all or part of any individual measure that will roll up to the sustainable objective. Sustainability certification is a term that we use. That is simply a way to designate one of the now ever-growing number of certification programs you might get into. Some of them I mentioned: LEED, Green Gloves, well building, all of that. If that's it, it's a certification, and then we have some specific terms that relate to these certification programs. Sustainability documentation is what you would have to submit in furtherance of that certification, and the certifying authority would ultimately be the party that's responsible for saying yay or nay, you've met the requirements or you have not. Under these exhibits, the architect has a lot of responsibilities. They have to hold a sustainability workshop early in there, and that's to get at the measures and to help develop the sustainability plan. They have to get to the plan, and the sustainability plan becomes a contract document. That is to say, once the plan is developed and the obligations are divided among the owner, the architect, and the contractor, those become contractual obligations that the parties have to meet in order to meet their contractual obligations. There are elements that the architect must achieve during the design process. That would include the workshop, the plan, and incorporating the measures into the drawings, among other things. And then during the construction phase, the architect has certain obligations to meet, or they may have some CA stuff they have to do. There may be a request by the contractor to substitute a product on the job, and then there's a back and forth between whether or not that's going to impact the sustainable objective in any way, and they may or may not be the party that's responsible for registering and submitting to the certifying authority. The contractor and owner, similarly, they have to follow the sustainability plan and perform the measures, and they may have obligations continuing through certification and even post-certification. I think you're all aware that USGBC GBCI has certain documentation requirements that follow certification. So that sort of wraps up the substantive part of the program with respect to the documents. I'm going to now turn it over to Hasti, and she's going to tell you how to access our fine documents.
Thank you, Ken, and thank you, Mike, for that informative presentation. I'm going to spend the last 5 minutes just talking about how you can obtain and use our contract documents that we've been discussing. Okay. So I'll talk about what available formats there are and what the cost is associated with each format. We'll talk about our purchase page and how you can go about purchasing the documents and where you can get additional resources. Stick around until the end. I'll talk about the small firms guide as well as our Learn page where you can go for continued education and resources for small firms. So our formats are as follows. You can see them presented on the screen. There's basically 4 ways that you can obtain AIA contract documents. You can purchase paper documents and check in with your local AIA component to see if they sell papers. You see the prices there, of course. With paper, you're just filling in the data points, and they will provide you paper versions. You can also do a basic single document, which is basically a paper document that you just print yourself on your computer. You can see the price points there, and basically you're adding your project data in the fill points, and that's the only thing that you can edit in the basic single document. This is great for those of you that have forms such as payment applications or change orders where you don't need to edit the language. It's a very cost-effective way, and you can purchase on our website and fill in the fill points and make all the purchase and go through the process directly from your computer. So it's also a very convenient way as well. There's 2 ways that you can access contract documents with our new online service. Basically, you can purchase a custom single document or purchase an unlimited annual subscription. For those of you that don't need to purchase an unlimited annual subscription, you might need just a finite number of contract documents a year. You want to have the ease to be able to pay as you go. Custom single document is for you. You get to purchase a document one at a time, purchase it when you need it. You'll be purchasing the right to finalize the document one time, but you'll be using the online service in its entirety, including all of the features, and you'll have your account set up in the online service with, again, unlimited numbers of drafts, but one final document of what you've purchased. Once you've made your purchase, you can purchase additional documents as you need them, have them saved in your account, and again, this is a great way to access the online service, have your contract documents, but only purchase when you need it. The custom single document is a fully editable document. So when you do purchase document one at a time and access it in the online service, you are able to edit the language in its entirety. And so the price is also reflected there. You'll see it's a higher price point than the basic single document, but it's because you can edit all of the language. If you do have the need for an unlimited annual subscription, you can do a single user, and you have the price points there. AIA members do receive a discount. To purchase either a basic single document, a custom single document, or an unlimited annual subscription, you'll go to our website, aiacontracts.org, and click on the purchase page. You will be receiving this PowerPoint, by the way, so we do have the links here on the slide for you, and you see here on the right-hand side information on the basic, custom single document, and then unlimited annual access as well. If you do make a purchase to access online service, I do provide online service basics training every week. It's a free webinar where you'll follow along with me as I do key tasks within the online service. I highly recommend it. Even if you've already started working in the online service, please attend the training because, again, it's free. It's only 1 hour, and I show you a lot of key features that will help you as you're putting together your drafts, finals, and project manuals, and so forth. If you have any questions, you can feel free to email me. My email is here, and again, you will receive the PowerPoint along with the recording of today's session. In closing, I'm going to just close with our contacts and resources. The Small Firms Guide is a wonderful publication that Mike Koger worked with along with our documents committee. The guide has a comprehensive list of AIA resources for small project practitioners, including small firms, sole practitioners, and custom residential architects. Please take a look. This is a free guide. We do have the hyperlink here for you, and you can also access it on our website, aiacontracts.org. If you ever have any questions about the online service ACD5, or purchase options, you can contact technical support. Any questions on our content, what a provision means, how to complete a form, what document is right for you, you can contact docinfo. And I've also linked to our Learn page on our website. This is where you can find additional education and resources and guides. So with that, we have reached our hour. I want to thank you all for participating in today's webinar, and also thanks to our presenters for a very comprehensive presentation. Again, look forward to the PowerPoint and recording, and we wish you a very nice afternoon.